Good afternoon, Your Honors. My name is Carl Ditto. I'm the appellant in this case. And before we get into oral arguments, I would ask the court to consider a motion that I had filed to strike the appellee brief in early March. This court filed an order on the 9th of March deferring action. So I wanted to see if the court wants to hear and rule on that motion at this point in time.
We have your motion. We have not ruled on that motion. We will properly rule on that motion at the time we rule on the case.
Okay. Well, do you want to hear from me regarding that motion, or just go straight into oral arguments then?
I think the motion's supposed to speak for itself, doesn't it?
Yes, Your Honor, it does. But then again, my briefs pretty well speak for itself too. All I'm really going to want to do is highlight some bullet points.
Whatever you want to do. It's your 15 minutes. It's
okay.
I suggest you might want to go to the appeal itself, because I think Judge McClarty is right. We have pretty much what we need from the motion.
I stand on my motion as it's written, and I would ask the court to reserve 5 minutes for rebuttal.
That'll be fine. Thank you.
My appellate brief raises 4 issues for consideration by the court, and I refer the court to my briefs for in-depth discussions of these matters. As far as background, I purchased this property on June 5th of 2019. There was a tax sale on June 6th of 2019, and the property was never redeemed. Mr. Bowers filed a quiet title action on July 2nd, 2020, but he failed to make any diligent efforts to serve me before filing a motion for service by publication. Mr. Bowers' failure to make this diligent effort to serve me prior to filing his motion for service by publication is the thrust of this appeal. A tax sale places a cloud on the title of property, and a quiet title action is the mechanism by which that cloud is removed. Thus, the effort to locate and serve defendants in a quiet title action should be more than that required by the delinquent tax attorney in a tax sale. Tennessee Code Annotated 67-5-2502 sets forth the actions required by a delinquent tax attorney to serve defendants and interested parties in a tax sale, and it also states that the attorney must make diligent efforts to do that. Therefore, the diligent effort to serve defendants in a quiet title action should be greater than those actions set forth by statutes for compliance by the delinquent tax attorney. Statutes and case law cited in my brief further define the diligent efforts to serve parties. Mr. Bowers employed a private process server who apparently made 7...
We have a question.
No.
I'm sorry, Your Honor.
What type of action, if any, that the plaintiff did take to serve you?
That's my next item, sir.
Go ahead.
Mr. Bowers employed a private process server who made 7 attempts to personally serve me. Then he filed his motion for service by publication. Constructive service by publication is a last resort effort to serve one whose identity and address are unknown. Actual notice...
They had in their possession the address that you had given the clerk, the court?
I'm sorry, Your Honor?
What address do they have was that stated? Was it not the address that you had already given to the court?
Well, Your Honor, I had never previously given an address to the court because I did not know that this action had been filed. But he did attempt to serve me at an address at 215 Shallowford Road, and that is, according to the process server's affidavit, the location where they did attempt to serve me.
Is that your address?
Yes, sir, that is my address.
And the attempt was made on how many different occasions?
I believe it was 7 occasions, Your Honor.
Okay.
Over about maybe a 10-day period.
Okay.
So, actual notice is required to parties whose names and addresses are known, and I cite the case of Turner versus Turner, which is a Supreme Court case from 2015 in my brief. I am easy to locate as set forth in my appellant brief. My identity and address are known, and I never attempted to evade service as alleged by Mr. Bowers because I never knew that this action had been filed, and since I didn't know it had been filed, I couldn't possibly have been attempting to evade service. I have appeared before this court on 8 separate occasions on appeal, and I've made over 140 trial court appearances in the past 20 years, and I have always been served personally and appeared before the court. This is the only time that I have ever had someone go to constructive service by publication. So my position is that Mr. Bowers never made a diligent effort to serve me prior to filing a motion for service by publication. The trial court should not have granted the motion for service by publication, and this entire action is fatally flawed and in violation of Rule 4 of the Tennessee Rules of Civil Procedure. Service of process must strictly comply with Rule 4, and personal service is mandatory. And I cite the case of Hall versus Haynes, which is a Tennessee Supreme Court case from 2010.
Let me ask you a couple more questions here on this. After you got in, I think you filed an answer, correct?
Yes, Your Honor.
Then discovery was served on you, sent by mail to this address, at least from what's in the record. No answer, plaintiff moved, compelled discovery. You didn't respond, you didn't attend the hearing. I mean, you continue, did you get, I guess from the record, it looks like the clerk's office was also sending you stuff to this address, and you never showed up for any of that either, or responded to that.
I don't know exactly what the clerk's office mailed to me or did not mail to me. What I do know is I never received any discovery requests.
And how do we know that? What's in the record? Showing that you didn't receive it.
I have filed several affidavits throughout this case attesting to the fact that I did not receive things or that I have not been served with the complaint and I was not properly before the court.
So you didn't receive the discovery request. Are you also claiming you didn't receive any of the notices of hearing that would have been sent by the clerk's office?
I did receive several of the hearing notices. I can't recall exactly which ones I did or did not receive. But again, my position throughout this matter has been that I was never properly served with a complaint, and therefore the trial court never acquired personal jurisdiction over me.
There is in the court's order that the court specifically ordered you to appear at a hearing on a certain date. I think it's June 27th. Did you appear at that hearing, and if so, or if you did not appear? Sure.
I don't believe I appeared at that hearing. I think I was out of town. And again, I rest my defense on the fact that I was never properly served with complaint or service of process. The only attempts that Mr. Bowers made to serve me prior to going to publication was affidavit by the process server claiming that they had tried to personally serve me at an address. And that is the only thing that they did, and I do not believe that that complies with diligent efforts. That's not even meeting the standard required of a delinquent tax attorney prior to the tax sale. And it's my position that the efforts required of someone in quiet title action must be greater than the efforts required of a delinquent tax attorney.
Well, help me here then. They had the right address. You've told the court that that was the right address. They told the trial court that was your address. They had the right address. The proof for the trial court was that they tried to serve you there 7 separate times with no success, for whatever reason. No success. Nobody, I mean, did they say nobody come to the door? I mean, what did they say?
Well, again, I wasn't present.
I understand. I'm asking what the record shows the process server said to the trial court.
The affidavit of the process server is part of the record. That is the only thing that I'm aware of as far as what testimony was presented to the trial court.
What else would there be?
Well, you know, a delinquent tax attorney, in addition to...
We're not talking about a delinquent tax attorney. We're talking about whether or not service was reasonable. Attempted service. Let me finish, then you can answer. We're talking about whether or not the attempt to serve you was reasonable. Now go ahead.
Well, again, the only thing they did was attempt service by the process.
You keep saying the only thing they did, so I'm asking you, what else should they have done before they went to publication?
They never sent me any certified mail. They never sent me any mail by first class. They never posted a property. They never took any other actions to try and locate me. No, I reside at the property, but I'm not there during normal working hours because I'm out doing what I do for a living, which is real estate. So the fact that I was not served, the onus is on the plaintiff in the lawsuit to make sure that the person is served that's a defendant. And that's what the case law says, is that service must strictly comply with Rule 4, and that the service by publication is an absolute last resort when the identity and address is unknown, that personal service is mandatory. That's what all these different cases say. And I was never served with the complaint. To this day, I've not been served with the complaint. I never received service of process. And Mr. Bowers never made any diligent efforts, as they're defined by statutes and case law, to locate and serve me, either before the motion for publication or after the motion for publication was filed. And the Tennessee courts have long held that participation, I'm already over. So, thank you, Your Honor.
You can finish your thoughts you were about to say there. Go ahead.
Tennessee courts have long held that participation in litigation does not constitute a waiver of insufficient service of process defense. And at every point in this litigation, my affidavits and my filings, I stated to the court that I had never received the complaint and that I was never properly before the court, and that the court had never acquired personal jurisdiction over me. Therefore, any orders that were entered by the trial court, I believe, are null and void as affecting me.
Okay. Thank you. You have your time for rebuttal. We'll hear from the appellee.
Good afternoon, Your Honors. Peter Ensign with the Hamilton County Bar. And you just know there was no record. That's the duty of the appellant to put the record in. I attended every hearing, so I will give the court some flavor of what the trial judge was actually relying upon. The process server and my paralegal both testified under oath at the final hearing, and the judge specifically found them both to be credible and truthful in their testimony. The process server said she made 8 attempts over about a 6-week, it was about a 4-week period to serve Mr. Ditto at the address that he has provided to both in other cases as well as with the Hamilton County tax assessor. She stated that lights were on and cars were there, but that her knocks were not, no one ever answered, and she had a phone number that was never answered. And so the court found, well, that was diligent effort to serve him at the address that he's provided. My paralegal testified that after Mr. Ditto filed his answer, which included it saying that he hadn't been served, the answer included a phone number. She called him and said, hey, if you're saying we didn't serve you, I'll be happy to provide that to you. He told her, that's your job, and hung up on her. That's what she testified to the chancellor. The chancellor found her testimony credible and persuasive, and so he found those efforts.
I'm sorry, is there a transcript in the record of their testimony?
Your Honor, he didn't provide the record. That's what they testified to at the final hearing.
Right, so there's nothing in the record?
No, he didn't provide the record. I was just giving you a flair. I was there. And he filed multiple motions.
I understand you were there, but you also know that we go by what's in the record. Now,
that's what the judge was relying upon.
Counsel, same thing I told him. Let me finish first, and then y'all can go. We understand who the obligation is on to provide the record, and we understand all that. But what I was just asking you was, I just wanted to know what was actually in the record before us, as opposed to what's from your memory, or what might be included in the judge's order, for example. No. Now go ahead.
I'm sorry, Your Honor.
That's all right.
The background on this is important. Several of these motions he filed, and then he never attended. The chancellor, throughout the coronavirus time, which has happened, has provided you can attend by either Zoom or WebEx to all of these hearings, wherever you are in America, as long as you have internet service. He filed the motions. He didn't respond. He didn't even show up. And eventually, after I would come 2 or 3 times, the judge would strike the motions. Every time he provided that exact same address that the process server had attempted to serve him at. Eventually, the judge started sending the orders himself by his clerk, so that they weren't just coming from my office, but they were also coming from the clerk, which included the order for him to attend. That order didn't speak to whether or not he was going to be in town. It didn't speak to whether or not he had been properly served. It ordered him to appear, and it did provide that he could appear via video. He didn't appear again. At some point, the chancellor had to go ahead and make a ruling because the case is just lingering. There's really nothing that would allow this court to find that the chancellor wasn't correct when the chancellor found that everyone was credible and that diligent efforts to serve had been made, and that therefore service of process was by publication was proper. There's nothing in the record. The record's not even provided, Your Honor, to say, well, Chancellor, you were wrong. The chancellor clearly stated what he observed and saw. The chancellor clearly notified him of all of these hearings that he chose not to attend. If he was concerned, he could have easily attended. This is the first hearing he's ever attended, because at this point the case no longer can be served because it's really been final down there. And it's not to be overlooked, Your Honor, that his only interest in this property was going to an heir of property owners a day or two before the property is going to go to back tax sale, and give him $1,000 for a deed to a property he's never even been on, so that he could be in line to redeem it if he so chose to. If the equities were even important to the court in this matter, there's no equities to this man that paid a very minimal amount to just work himself into some litigation and then never even participate in any of it, and now say, well, they didn't follow all the rules. Well, the chancellor said that we did. And I don't know how this court can say, well, Chancellor, you were wrong, when the chancellor was the one that heard all this testimony. And the chancellor made effort.
I don't think that's the proper response. You don't know how we can say that he's wrong. That is really not the proper response, but go ahead.
Well, there's nothing else to say about it. You can say whatever you want to say. The chancellor made an effort to make sure that he was allowed to participate in the litigation, and he chose not to attend. And the chancellor did his best to send him notices, and he didn't attend. And to come up now and say, well, Chancellor, Mr. Bowers, you didn't follow all the rules. If you send it back, we're just going to do it again. So we're not that concerned about it, but we're just saying it's just an incredible waste of time.
Thank you, counsel. We'll hear from you in rebuttal.
Thank you, Your Honor. Very briefly.
Let me ask you, did you file a motion to strike or amend the order compelling you to respond to discovery requests? Did you file a motion to strike or amend the court's order where the court ordered you to answer a discovery request?
I don't honestly remember, Your Honor. If so, then it should be in the appellate record because...
Yeah, I think it is. And then from what we have is the court set it for hearing and you didn't show up for hearing. So if that's so, if that's what the record shows...
Yes, I was out of town on the hearing date, Your Honor.
Well, okay, you know, I understand. But for whatever reason, all the court knew was you didn't show up on the hearing date, on your motion.
Okay, Your Honor.
Yeah.
Again, the primary thrust of this case, as far as I am concerned, is the diligent effort required of a plaintiff in a quiet title action to locate and serve defendants prior to going to publication, constructive service by publication. The only thing that happened as discussed was a private process server. There was never any other action taken. And to me, that is a lower requirement than is placed on the delinquent tax attorney in the process of the tax suit. And then since the tax suit places the cloud on the title, the service requirements of a quiet title action should be greater to make sure that anyone with an interest in that property is properly before the court before they are divested of that interest. And the chancellor, as far as I know, and I think the appellate record reflects, when the motion for service by publication was heard, there was nothing else in the record, as far as I know, that the chancellor directed them to take any further actions other than that those by the process server. And I think that they should have done other things. They should have tried service by first-class mail. They should have tried service by certified mail. They should have tried posting the property. These are all things that are required of the delinquent tax attorney according to the statutes and the case law, and yet they did not happen in this case. And he also mentioned that I purchased the property the day before the tax sale. That is true. I had located Mr. Gilliland, who was the heir of the delinquent taxpayers, many weeks prior to the tax sale and had been in communications with him. And we finally reached an agreement 2 or 3 days before the tax sale. I drafted up the appropriate paperwork and everything was completed. So I just wanted to make sure that it doesn't sound like I went out at the very last second and found this guy, got him to sign a quitclaim deed just so I could fight a lawsuit. You know, I spend a lot of time in lawsuits because of tax sales that I wish I didn't. And that means every minute that I spend in lawsuits because of tax sales, I can't spend on other things that actually make money for me. So, and therefore I would ask this court to vacate or reverse any of the orders of the trial court that affect me. And if the court has no further questions, that concludes my argument.
I hear none.
Thank you, Your Honors.
Court's thanks to both sides today for your oral argument on this. We appreciate you being here. Yes, you're excused.